I think I got it.
That's different from the other day, right? You were making a video.
Yeah, I was using my phone then.
Oh.
Yeah. At the Law Day thing?
Yes.
Yeah. So we re-rented this one.
Oh, cool.
And we also rented these little microphones that are supposed to record the sound separately. So I'm going to try my hand at editing and putting them together. Because last time, you couldn't hear very well. So,
Well, that would be great.
yeah, I'm really hoping so. It's $50 to rent. And then I don't know about the microphones. We might invest in the microphones because they're not too expensive just to buy them. Like $150, $175. So might just get some of those.
Hello,
Now
everybody.
these.
Thank you for coming. My name is Mark
expensive.
Webster. I'm the president of the Friends of the Judson Law Library. Before I introduce our speakers, I want to bring to your attention that this is part of a monthly lunch series. And the next one coming up is on June the 22nd. James Joey Wilkerson, who you might recognize from Leo, is going to be here to talk about Title IX. He's, I understand, a very good speaker, so I invite you all to that. And then we also are going to have a CLE here on June 27th. Robert Hellringer is going to speak about the laws that were passed in the last legislative session. That's worth 1.0 hours of CLE credits. It's $40. So if you want to go, we'd love to have you. Today, we're going to be talking about the book Pleading Out by Dan Canon. I don't know if you've read the book. If you haven't, I urge you to read the book because it's very much worth reading. Dan, I think this is his first book, if I'm not mistaken. He is a graduate of U of L, and he also went to the U of L Law School. He teaches at U of L, and he's part of a legal clinic there, too. Judge Cunningham was a successful lawyer, and had some big judgments, both in Alabama and Western Kentucky, and then ran for the circuit court judge position, which he served 16 years in that position. And now he's he's a mediator. So this is not a debate. So what we had in mind was that Mr. Cannon would speak while sitting here, make some comments about his book, maybe go for about 20, 25 minutes. I know it's going to be hard. You're used to 50 and 75 minutes. So,
Mm-hmm.
but and then Judge Cunningham would maybe have some comments after that. If Mr. Cannon thought he needed a rebuttal or something like that, we'll reserve 5 minutes. Although this is not a debate, I mean, you might just think that you have something to say, you know, that you forgot or didn't want to add. But then we'll have about 20 minutes of question and answer. So with that, let me shut up and let you proceed.
Well, thanks everybody, and thanks so much for having me. And it's a real honor to sit here with Judge Cunningham. So I've really appreciated his work on the bench and admired him for as long as I've been a lawyer, I think. The book, and I think that many of you are practicing lawyers, probably all of you are in practice. You're probably wondering, why would I read a 300-page book about plea bargaining, and that is the thing that I do every day? And you know, the answer to that question is, number one, I think that the book is fun, but I'm biased in that regard. I've tried to write something that is engaging for regular readers that don't practice law. But I still find that, you know, when I do book tours and I do book events and that sort of thing, that the majority of the people that come to talk to me about the book are lawyers or law students that have read it, and they're interested in the history of how we got to where we are now. I think most of you will know that the criminal legal system in the United States is not that great. It's got some flaws, right? There may still be many of you that are in the camp, or some of you that are in the camp of, like, well, this is not a great legal system, but it's a really good one, and you know, we just can engage in some reform and a few tweaks here and there, and then we can have a really, really good system. And I think when you stack it up against the criminal legal systems in the rest of the world, by and large, that's not true, right? We are still incarcerating way more people than anybody in the history of the world. Our arrest rates are through the roof compared to most common law countries and most industrialized countries. And pretty much any metric that you want to select, that you want to pull out, and compare us to what's going on in the rest of the world, we're falling behind in terms of rehabilitation, in terms of incarceration, in terms of any sort of criminal justice metric you want to use. And arrest rates are a prime example, so I'll just sort of refer back to that. If you look at the average arrest rate per 100,000 people in Canada, you're looking at 500 to 600 people every year. And in the UK, you're looking at somewhere around 1,500 to 1,600 people, 1,600 arrests per 100,000 people. Does anybody want to guess what it is or know what it is in the United States? No, no cheating. I don't know if I put it in the book. I think I did. Okay. Any guesses? No? Okay. I've gone into law professor mode. So, I'm going to start cold calling people. No, I'm just kidding.
Nobody leaves until you answer or ask a question. It's the rule.
That's a real way to turn off the crowd. Like, it's okay, I escaped law school, so I didn't have to do this. So it's 3,000, right? So we are double the arrest rate of the UK, and about 5 times the arrest rate in Canada. So you look at statistics like that, you're like, all right, well, there's 2 possible reasons why we're in this position. And it's because either one, we have people in our country who are more predisposed to being criminals for some reason. Which is like there's something in the water, or there's too much sex on TV, or it's violent video games, or something like that. Just something that makes American people more predisposed to criminality than folks in other common law countries. Or we've created artificial mechanisms, the other possible explanations, that we've created mechanisms that sort of artificially create an abundance of criminals. And my argument, as you might guess in the book, is that I think that the latter explanation makes a whole heck of a lot more sense. And the chief mechanism, what I'm trying to argue here, is that the chief mechanism for creating all those criminals that we create is the plea bargain. Think about what a plea bargain is, right? Because this is something that all of you are accustomed to as sort of a facet of your daily practices. And so we don't think about what it is and what it does all that much because you're so far down in the weeds of the system. There's, okay, this is how you do it. This is how you do your job. And it's probably what you've been taught since day one. This is just part of the system. When you examine it, it really is a way not only to speed up the process of creating lots and lots and lots and lots and lots and lots of criminals, right? Way more than anybody else in the world. It is that, and I think it's chiefly that. But it's also a means of almost totally removing the public from all of the machinations of criminal justice, right? So it is, in other words, it is a way that we have sort of we as lawyers and judges and the system writ large have excluded the public from affairs of criminal justice. And so in writing this book, I'm asking, why? Number one, how did we get to the point where, historically speaking, how did we get to the point that this is sort of the foundation of our criminal justice system? Justice Kennedy said a number of years ago that plea bargaining is the criminal justice system, right? It's not just a facet of the criminal justice system, it is the criminal justice system. So how did we get to that place? And is there any correlation between where we are as the United States and when you compare all of our criminal justice outcomes to what's going on in the rest of the world? I've said that we're an outlier on just about any statistic that you can think of. And we're an outlier when it comes to plea bargaining too, in a big way. Right now, we, about 95 to 97% of all criminal cases in the United States end in a plea bargain. That's a lot. And the number is going up, right, every year. We see the number of criminal prosecutions continuously rise and the number of trials, the raw number of trials, and certainly the percentage of trials, but the raw number of trials continues to go down, and that's been a trend since the 1960s. So even though we're at somewhere around 2 to 3% of all cases getting tried, that number continues to go down. And that also makes us an outlier among all the other countries in the rest of the world, including the countries that have similar legal systems, like I said, Canada, Australia, the United Kingdom. They all top out somewhere around 75 to 80%. Right? I think the highest you get is in Scotland, where they are, I think 80% of their cases are resolved via a guilty plea, mostly via plea bargaining of some kind, right? And we're sitting at 97%, so that's a big difference. So what I'm trying to do in the book is to see whether or not there's a connection between the enormous number of plea bargain cases that we have here and these totally monstrous criminal justice outcomes that I think everybody in this room knows. The historical thread, I think, is particularly interesting because when you look at the history of plea bargaining, you start to poke at why we have this system in place and why we're so much different than the rest of the world now. And if you go all the way back to the 1830s, and I'm not going to get too deep into the history for these because I can already see eyes starting to glaze over and go, oh good, a law professor's going to talk to us about the 19th century. But if you go back to the 1830s, it's an interesting situation because prior to 1830, at least as far as we can tell, we know what criminal record keeping is like now. It's not great. It was really, really bad in the 1830s, but as near as we can tell, there really was no such thing as plea bargaining in the United States prior to 1830. And then in Massachusetts, you see the number of cases, which is really one of the only places where we've got good records on this sort of thing. You see the number of cases that end in guilty pleas start to steadily tick up, right at 1830. In fact, I mean, and to just sort of underscore what a big shift that is, there were prosecutors who were themselves getting prosecuted for cutting deals to defendants as late as the 1840s in Massachusetts. So this was a totally taboo sort of thing. When you get into the case law from that time period, you see that even where defendants have come to the court and said, yeah, I did this murder, or yeah, I did this horrible thing, I don't want a trial, I want you to, I want to just throw myself on the mercy of the court. The courts are saying, no, 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 we don't like that. We want you to go to trial. We don't want you to take a plea, right? So even taking the bargaining out of the equation, courts were not really super excited about guilty pleas at all. But that starts to change in the 1830s in Massachusetts. And again, you see these numbers go up. So we go from 0% plea bargain cases, so far as we know, in the 1830s in Massachusetts. And then by the 1850s, nearly 50% of all the criminal cases end in a plea bargain, or end in a guilty plea, which we think is the result of plea bargain. By the 1880s, that number is almost 90% in Massachusetts. So you have this thing that really catches fire over about a half century in Massachusetts. And why does that happen? One of the things that that I talk about a lot in the book is looking at the burgeoning labor movement that was happening in Massachusetts and in New England, all over New England at that time. And you see, along with the rise of the labor movement in the 1830s, the 1830s is a very important decade. Without getting too far into it, the 1830s is a very important decade for the labor movement in the Northeast. You see the rise of plea bargaining cases and the rise of prosecutions of individual working people start to rise at the same time that the labor movement really starts to get into full swing. Along with that, you've got the introduction right before that of universal white male suffrage. So what that means is not just that white non-landowning men are for the first time able to vote. That really happens in Massachusetts for the first time in the 1820s. But they're also for the first time able to serve on juries. And juries were enormously powerful during this period of history, and a lot more powerful than the way we think about juries now. We think about juries as being the finders of fact. Well, they were fact finders at that time, but they were also able to say what the law was, right? So these labor cases, labor prosecutions are coming before the court, and you're starting to get juries of working class white men that are saying, actually, we don't think it should be a crime to organize. We don't think it should be a crime to do the things that the court, that Massachusetts wants to prosecute these working class men for doing. And so that becomes enormously threatening to the ruling classes in Massachusetts at that time. And they take action on it. They do two different things. At least that's my argument in the book. One is they take power away from juries via statute. First via court decision and then via statute, right? First you have the Chief Justice of Massachusetts saying, okay, juries, you can't decide issues of law anymore. You're just going to be consigned to issues of fact. This is enormously controversial, by the way, in the 1840s and 1850s. And then there's a Massachusetts Constitutional Convention that happens in the 1850s where they revise the Massachusetts Code to say that juries no longer have the power to decide issues of law. And that's enormously controversial. But it's something that's being pushed by the old school sort of Boston Brahmin ruling class people that make up almost the entirety of the legal system at that period of time. So they take that power away from juries, and at the same time you see the rise of the plea bargain, right? Coincides with it almost perfectly. And you see those cases start to tick up. And part of my theory in the book is that it's an overall effort to keep the court system insular, basically, to keep it confined to the sort of wealthy Brahmin types that were running it in the first place, and to exclude the public, especially since the public was showing itself to be more and more dangerous in the rise of universal white male suffrage, if that makes sense. So you have this gradual uptick in plea bargains that happens in the 1830s, and this really explodes into the rest of the country during the era of Prohibition. And still, from Prohibition on, because during Prohibition you get the federal government involved in law enforcement in a way that they've really never been involved before. You've got this, the creation and the dramatic expansion of federal enforcement mechanisms like the FBI. And then Congress gets into the game and says, yeah, actually, we really like this. We were leaving this to the states before, but we really like the idea of expanding the federal criminal code every year. And so this persists. So when Congress creates all these toys during the Prohibition era to enforce Prohibition, those toys still exist after Prohibition is no longer a thing. And so, in fact, the year after Prohibition ends in 1934, Congress passes 9 different crime bills to just criminalize everything under the sun. And Roosevelt's Attorney General, in fact, gets, in his first nationwide radio address, says, yeah, okay, Prohibition was really bad, but that's over now. But you know what's really, really bad, and what we really got to focus on right now, and that's narcotics. And so the era of narcotics enforcement really begins in earnest during that period. And of course, that takes us into the drug wars of the 1960s and 70s and 80s that all of you are familiar with. But during that period of time, during the 20th century, the mid-20th century, this is still an issue of vigorous debate. There's still an ongoing public debate. There's certainly a debate within the academy and within the courthouse, but there's a public debate over whether or not we really want to have a criminal justice system that is based almost exclusively on backroom bargains, right? Nobody else is doing it that way. Why is this on the rise in America? And in fact, there's a national conference that meets of criminal lawyers that are advising the White House that meet in 1973. And they issued a recommendation that all plea bargaining ought to be done away with by 1978. I hate to spoil the book for you, but that doesn't happen. Right? Plea bargaining, in fact, the opposite happens. And there's a case called Bordenkircher versus Hayes. It is actually the result of a criminal prosecution from down the road here in Lexington. And Vince Aprile, you guys know Vince Aprile? on that case, and I talked to him for this book. Really, really fascinating stuff. But just to put that in a nutshell, Paul Hayes is a horse transporter in Lexington, and he gets arrested for writing a bad check worth $88.30. And he had had a felony 10 years prior. And so the prosecutor comes to him and says, "All right, well, I'm gonna give you 5 years on this bad check." And Paul says, "I know, I'm gonna take my chances with the jury. I don't want 5 years on a bad check." The prosecutor says, "All right, well, you don't want to do 5 years on a bad check. I'm gonna hit you under the habitual offender statute, and you're gonna get life." And Paul Hayes says, "Well, respectfully, no thanks. I'll take my chances with the jury, and we'll see what happens." And at the trial, what the prosecutor says is, "Didn't I tell you, Mr. Hayes, that if you," his words, "if you put the court through the inconvenience of a trial, well, I was going to hit you with this extra charge, and you were going to do life." And so, of course, he's convicted and gets life in prison over an $88.30 check. Well, that goes all the way, that's very controversial, right? That goes all the way up to the United States Supreme Court, and Vincent Priel tells me that while he's representing Paul at the United States Supreme Court, he's getting all these letters from prosecutors all over the country saying, "I can't believe what happened in this case. My God, you mean that he was your client was threatened by a prosecutor just because he wanted to go to trial? That's just outrageous. I would never do that." So I don't know if those prosecutors were telling the truth at that time, but of course we know now that this is basically the way the system works, right? You're pretty much able to use any carrot or any stick that you want in prosecution with relatively few exceptions. And that's because of the Bordenkircher decision. What the Supreme Court says in Bordenkircher is anything goes, right? It is the prosecutor's job to persuade a criminal defendant not to go to trial, and here Mr. Hayes wasn't persuaded, and so sorry about your luck. Pretty much anything goes, any carrot, any stick. And that's where we've been for the last 40 years or so. And it really is, Bordenkircher is particularly the decision that I think has led us to be an outlier among other countries that do plea bargaining, right? In the sense that you've got some controls on what prosecutors are able to bargain with that simply don't exist in the United States, in other common law countries. So I'll shut up there because I've probably gone way over my time already. But there's some interesting other stuff that we could crack into in terms of, jurisdictions that have experimented. I covered all this in the book, but jurisdictions that have experimented with doing away with plea bargaining and the sort of surprising results of those things, because I think that probably what Judge Cunningham is going to hit me with is what everybody else hits me with on this, is that, well, if we do away with plea bargaining, won't the entire criminal legal system come grinding to a halt? Right? I've heard that since my first year of law school. And I think the short answer to that is no, I think that's not true. And we do have some historical precedent to see that it's not true. But I'll let Judge Cunningham take it, and we'll talk more about that later.
All right. So, literally the thing I was going to start with is kind of what you started with. And it's on page
Does everybody
229.
Everybody have their copies? You can follow along.
Carmichael's carries. And it's basically, there's one of two things going on, because you have so many people incarcerated in the United States versus anywhere else. And in fact, now, this datum is somewhat out of date. It's probably 3 or 4 years ago. In particular, if you look at women, if Kentucky were its own country, and all the other states were treated like, Kentucky incarcerated a higher percentage of its women than any other place on the planet except Oklahoma. And I was told that Oklahoma had passed a couple of statutes. It was anticipated we were going to pass it and make it to #1. I don't know if that ever happened, but I'll ask the women here, what is it about you Kentucky women folk that makes you so felonious that we would have such a horrible rate here in Kentucky? And the answer, of course, is it has nothing to do with the nature of Kentucky women versus, heaven forbid, Indiana women. It's not that at all. But the question that I want to pose is plea bargaining a symptom of the bigger problem we have in criminal justice, or is it the cause? And I would like to respectfully suggest it's a symptom of the problem. And I'm gonna sound theological here for a moment, and you're probably thinking Cunningham's gonna talk religion. Oh my goodness. Lightning bolts. We got 2 floors above us. The bolts probably can't catch us in here. What I think is the problem is what I call the difference between Old Testament justice and New Testament justice. So, in the Old Testament, just to give you an idea, Deuteronomy chapter 21, verses 18 and 21. If you don't, one of the 10 Commandments is honor your parents. And in Deuteronomy it says if you don't honor your parents, basically your parents go out and round up all the elders and you stone that kid to death. That's pretty harsh for disrespecting your folks. Not many of us would probably still be alive if we had that kind of justice. But that's the mindset. In contrast, in the New Testament, in John, they come up to Jesus and they think they're going to catch him in something. They say, well, this woman's an adulterer. Let's stone her. Here, want some rocks. And he says, well, let's let the person who's without sin throw the first one. Nobody ends up throwing one. They all end up walking away. That's more the New Testament look on it. And again, I'm using that only because these are things we've probably heard in our life. It doesn't have to be the Christian focus, but you get the idea. There's a harsh way of looking at how we have to deal with people who err, and a not so harsh way. And there's a simple code of conduct, and then it can get really complex. So, Moses sees God, or I guess he doesn't actually see him, but his hair turns white. He got close enough, his hair turned white. And he hands him 10 rules. Here, get the Hebrews to do these doggone things. I just need these 10. Now, he brings them back, and before you know it, the Hebrews have turned into about 600 some odd rules that you're supposed to follow. And even the ones who are good at that, and I'm going to talk about Micah here for just a minute, admittedly an Old Testament prophet, but he had kind of a New Testament message for me. So he's down there and he's fussing at the Hebrews like, what are you doing? We're following all these 600 doggone rules and you're telling us still not enough. What is it God wants? He said, it ain't that complex. Act justly, love mercy, and walk humbly. That's the part you're not getting. And so I think the problem we have, we've taken the 10 Commandments and turned it into, I shudder to think how many statutes and regulations we have about what you can and can't do. So that's the problem. And we make the punishments very harsh because we think if we just tell you you're not supposed to do it and we make the consequence harsh enough, you won't do it. Well, first off, that really doesn't work for most folk. And particularly if you have a substance use disorder, particularly if you have a mental illness, that just doesn't cut it. So that's the problem. Jesus came along, God looked down and said, my 10-point plan just didn't work. I got to simplify it for him. Sends Jesus down, he said, I'll make it simple. 2 rules. 2 rules. Honor me and do unto others as you'd have them do unto you. 2 rules. We've kind of gotten away from that. We've made it a little more complex than that. As Professor Canon eloquently puts in his book, we've been traveled for as long as we've been around. And we've always singled out certain groups of people to treat them worse than we treat ourselves. He talks in great detail, of course, about criminals, how they become an outcast. But you could talk as easily about LGBTQ folk, racial stuff. We've always tried to say who's in and who's out. And that's a problem. And it's particularly a problem in America because we don't do anything in a little way. We're the go big or go home kind of folks. So quickly, who else has sent, aside from America, people to the moon and more importantly brought them back? Nobody. Who else was able to build a canal through Central America to connect the oceans? Several people and countries thought, some even tried, only America did that. In World War II, when it broke out, we had like the 15th biggest army in the world. I mean, time was over with, we were literally overwhelming everybody because we got to work and we hit it and get it. That kind of can-do, let's pour everything into it attitude ain't such a great thing when it comes to criminal justice. But that's what we've tried to do. We've tried to just hit it and get it with everything you could think of, and it just isn't working. So I say we need fewer crimes with reduced consequences, and plea bargaining will take care of itself. To take Paul Hayes as an example, he is given a check that's not made out to him by a buddy and takes and cashes it. When he's first arrested, he's like, oh, I just found it. He didn't commit a crime. The problem was, he was PFO, whatever they called it back then, he was PFO eligible, and that meant life. The problem wasn't plea bargaining and an honorary prosecutor, although that didn't help. The problem is, you should never have been facing life because you passed an $88 check that wasn't yours. That, in my humble opinion, is the problem. That was a toy that the government had given prosecutors that the prosecutors should never have had in the first place. Now, why would legislators do that? Because they're Old Testament kind of folk, and most people voting in a place like Kentucky certainly have an Old Testament kind of mindset. So I would suggest that's the thing we have to work on is trying to be more New Testament in our thinking about the legal system. Professor Cannon talks about financial aspects of things often in a class sort of context, upper class versus lower class. I will suggest there is one aspect of money and how it impacts criminal justice that could actually be beneficial. First off, would you suggest that we're passing legislation because the ruling elites want to keep the lower class? You give legislators in Frankfurt far too much credit. It's an underwhelming process when you go up and talk to those folks. But in my term, probably 5 years ago, they actually started to say, we're spending far too much money incarcerating people. I mean, you can have this mindset of, we just want to lock a bunch of people up, but it costs a boatload of money. It's expensive. And so even Frankfurt was starting to think about, what do? We got to control this stuff. And I'll never forget Damon Preston showing up at a hearing. I don't know if y'all know, Damon Preston is basically the head public defender in the Commonwealth. And every time I've seen him talk, he impresses the heck out of me. But he gets up and he says, you all talked a good game last session. Y'all were gonna try to ratchet back. You passed, these numbers I don't remember with precision, but 30 some odd statutes that either created new offenses or enhanced the penalties. You passed 3 that reduced, and one of them had to do with mistreating dogs or something, but that reduced or eliminated crimes. He said, that's when you're talking, when you're actually got that in your mind and you're talking about it, that's the outcome of a legislative session. And that's, I suggest to you, is the problem. Now, I don't just blame legislators, because when they go back and talk with their constituents, most of them want to hear, what are you doing about crime? What are you doing about crime? And that's I think, the problem. Now, I often tell people when they say, we got this problem in the criminal justice system, we need to figure out how to fix it. Charlie Cunningham can fix it. And they'll say, really, what? And I said, just understand, my fix is going to cost a lot of money. Then they lose interest. They really don't care what I got to say. So, for example, I've often said, I'd hire twice as many public defenders and pay them twice as much. Then they'd stick around longer. They would have more time to devote to their cases. They could take more cases to trial because they had fewer clients to take care of. It would still be an insane workload. Make no mistake, you have our public defender's workload, and it's still insane. But it would only be quasi-insane instead of categorically insane. I do the same thing with the prosecutor's office, because as he points out, I think something that people don't think about, they don't have enough time to screen cases. I don't know, like, what fraction of time, Elizabeth Young Brown, do you spend, you think, in a given week or month screening cases to decide what should be pushed versus not?
I don't know how to quantify it like that, but I think sufficient time generally.
Okay. Well, but that's, I picked the wrong prosecutor. In places where they've said, we're going to try to reduce some of this stuff, part of the problem is prosecutors have to have time to screen cases. So, again, my fixes are expensive, but not just in money, but societally, because the consequences of having lots of people being prosecuted has a lot of negative consequences throughout society. We're whining right now that even though our unemployment rate is 3 point something, the lowest basically it's been, but we struggle to, when people want to come here with new facilities and what have you, because the workforce isn't as numerous as we'd like it to be. There's too many people who are not in the workforce. In other words, that's 3 point something % of the people who could work or would work. And we have too many people who've taken themselves out of place, in part maybe because they're convicted felons. And there's a whole laundry list of people, jobs rather, you can't do if you're a convicted felon. I used to keep a little book about 1/4 inch thick, and all it is was, here's bad stuff that happens to you when you become a convicted felon in the Commonwealth of Kentucky. And I kept the table of contents laminated on the defendant's table, so whenever anybody was pleading guilty, I said, just look at the table of contents of that book. Here's all the bad shit that's about to hit you. So it would be better, as opposed to just throwing more money at the problem, to ratchet back consequences and the number of crimes. And you could do that really, if you were smart about it, without greatly endangering the community, particularly if you paid a little more attention to substance use treatment and mental health. Easy to say, really hard to shift that oil tanker in its direction. Now, what problems do I have with the book? I'm not going to read the word I actually put down there. There's a lot of hyperbole in the book. God bless you. On page 8, in America, everyone is always guilty of something. So, Mark, what are you guilty of today?
Good to ask the
Page 10, quote, and this is in italic, so it must be important. The American legal system was designed by people in power as a tool to keep them in power at whatever cost, close quote. And he says, right after he says, this may sound melodramatic or exaggerated. I would say yes, Ben, it does sound melodramatic and exaggerated. And in fact, if you look at the 4th, 5th, and 6th Amendments to the United States Constitution, it's hard to figure out how the elites were putting those in there in order to keep the lower classes down. And that's not even getting into civil law, which is the part they should really care about, because that's where we would take their money. And actually, the civil legal system is pretty good at taking money away from people. So, just a little over the top. And then page 110, nothing stops a prosecutor from running roughshod over a defendant. Do I have agreement from the prosecutors in the office that there's nothing that stops you from running roughshod over a defendant? Again, a little over the top. But I will say, even if it were all true, you could as easily say, and it's because of white men, as to say it's because of plea bargaining. Because if you look at most of the anecdotal, bad, really bad things that are pointed out in here, almost all of that, there's either entirely or predominantly white males involved in doing it. But it's not because there's white males, it's other things. So I'm just not a big fan of hyperbole. So that's a problem I have with that. I will also say it's a little harsh in the way that it describes the role of judges and public defenders. So when I read all of this, I think, have you met Rob Eggert? Do you know Rob Eggert? All right. Again, I wish we were trying more cases. And I acknowledge they're going down and down and down. And so when the pandemic hit, and there was a big, what are we going to do with this log jam? Well, we were basically out of commission for 1 year. And I told people, if you look at how many jury trials I had in 2009 and 2010, the first 2 full years I served as a judge, and then look at how many jury trials I tried in 2018 and 2019, the last 2 full years I had before the pandemic, it was about half. I was the same judge, I like trying cases. I would rather spend my week trying a case than the other stuff that one does as a judge. They just weren't coming. And I will say, post-pandemic, and my point of that was, we will cure the logjam in 1 year. If I just try as many cases as I used to, bring as many trials as we used to, and in 1 year, we're caught up. And we tried a lot of civil stuff in my division, post-pandemic. I didn't have a single felony trial from the time the pandemic began to the time I left the bench in December, which I don't, now, there were a lot. Some of my colleagues seemed like they were in trial every other week post-pandemic with criminal cases, but I don't dispute that statistically jury trials are becoming a rarer thing. Again, I don't necessarily attribute that to plea bargaining so much as, again, there's just a lot going on and people overwork. I'll grant you that. So that's a point I would make. I don't know too, when penalty ranges came into this is just an ignorance on my part. I'm guessing that back in the early 1800s, that the statute was basically, if you commit a murder, here's the consequence. If you steal, here's the consequence. We eventually started creating these ranges, and that necessarily almost mandates some level of bargaining, but I don't know. I don't have a lot of stomach for people who say bad things about people in the jury service, and you don't, but you kind of imply that anybody with any sense will get out of it. And
No, what I say is that it's very easy to get out.
yeah,
It's made very easy to get out.
To be precise, you say that judges will let anybody off who wants, and for example, if your hamster needs water, then you're off jury duty. And I'm pretty sure you've never heard anybody say, Judge, I should be excused because my hamster is thirsty.
We understand that there are rhetorical devices that are being used in this nonfiction book that
Well,
it's intended for product.
and what I'm suggesting is that, and I wrote something at the OBA Bar Groups about this years ago. We, as a legal community, while it's easy to talk this way about jury service, it's important for us to make sure people understand how important it really is. And broadly state, I've had the great privilege of talking to a lot of people after they did jury service. And almost without exception, they were fascinated with it, took it very seriously, and it changed a little bit of their thinking. As you point out, that one of the great benefits of jury service, it makes you more civic-minded. It does. I can confirm that from talking to a lot of jurors. The worst thing that makes them think poorly is bad lawyering. And at the risk of sounding modest, I guess bad judging, but I've never talked to a jury that was confronted with bad judging. So, but I'm guessing that would be a negative. But I had one or two. Usually, I would joke with lawyers. I would always tell the juries at the start, it's really important. The quality of this is going to depend on a good lawyer, but the good news is you got good lawyers here on both sides. And about twice I had my fingers crossed behind my back when I said it. But broadly speaking, we have good, competent lawyers practicing here. So for juries, it's important that we say nice things about them, we do good jobs when we have them in our presence, and be mindful of their time and don't squander it. That's a pet peeve of mine, that I'll say, okay, we're taking a break, everybody be back at 10:45, and at 10:50, some lawyer comes wandering in, and I'm like, this is why they gave me a gavel, but my aim has gotten bad over the years. So I just, we don't really disagree about that. I'm a little, and I want to say this too, just because of the circumstances. I think, I went and bought his book several Fridays ago, because I thought, I'm going to talk about how I should read it. And I bring it home on a Friday after I read the introduction and the last chapter. I'm like, first, the introduction, okay, and let me see what the solution is. We should talk about that a little bit. But I remember going to bed that night thinking, thank God we have Tom Wine in Jefferson County, because I think Tom tempers a lot of this that stuff that can happen. And then I go up next morning, he's normally at Panera for ex-judge's coffee on Saturday morning. He wasn't there, and I found out he's dead. And I just felt so horrible for the community that had happened. So it's not that we disagree about that something's got to be done. That this can't be the way that things work. It's just wrong. And if there was a statutory mechanism to wipe plea bargaining out, I'd be willing to listen to it, but I don't think that, and I will say this, and again, this is the engineer and Charlie coming out. When you talk about the difference between us plea bargaining 95, 97% of cases versus Scotland 85 versus Canada 80, that's just a quantitative difference. Now, if you're one of the ones who got screwed over, that quantitative difference works like hell. But it's really it's not a qualitative difference. It's a quantitative difference. And that's why I'm saying if we ratchet back how many things we criminalize, if we ratchet back what the consequences of those crimes we leave are, we will probably get closer quantitatively to other places. And then we can really get focused on the qualitative differences between us and other places and what might make us better. So I'll shut up.
I mean, I'm happy to.
Ready for questions?
Yeah, we can open it for questions, or we can talk more. But.
All right, so what we'll do, open it for questions. Here's the first one back here.
Yeah. What is the point of the book?
The point of the book is to trace the historical roots of plea bargaining.
I mean, the solution.
Good. Yeah, so
It was unclear to me what your proposal was, because I thought, well, it'd be like, this is unfair.
yeah.
And the major example you used is no one rode roughshod over anybody. A career criminal committed an offense, didn't want to take his deal, and they let the voting men and women of the community make a decision on him. You know, no one abused him. He got his fellow citizens said, you know, we've had enough of you, take your life sentence. So is plea bargaining good or bad? Tell me your conclusion.
I think it's definitely bad for all the reasons
Okay.
that I led with. I mean, in the sense that it's, you know, I don't think that there's anything inherently wrong with plea bargaining. I think that there's plenty wrong with the way that we're doing it. Right? I think that there's plenty wrong with having a system that is premised almost entirely on the plea bargain, right? And so when you say things like running roughshod over a defendant, I mean, read that in context, right? And it's the sense that we are allowing, by and large, when you compare our system to anybody else in the world, prosecutors have more leeway, again, as I said before, to use more carrots and more sticks to get a bargain and to talk somebody out of trial than any place else in the world. And that removal, and you know, Judge Cunningham asks, is plea bargaining a cause or a symptom? I mean, I think it's a little of both. But my point is that it's the chief enabler of a lot of what's wrong with our system, because it's done so much to remove the public almost entirely from the mechanisms of criminal justice that we have in place.
So the argument is because of these legislative, you know, we vote in the legislature there, they pass the law is too harsh. Because if I'm a prosecutor, I'm going, this is what the law is, I'm going to lay it out.
Let me give you an example from the book that I thought was a very good one. So in New Orleans, I never knew there was such thing. You could be convicted of murder with less than a unanimous verdict. Under state law,
Right.
it took, it wasn't 1 3/4, it was maybe.
It's not
80.
constitutionally required to be unanimous. Yes, you can vary.
So there was, somebody began a citizens organization to try to change that. And even with the mindset that I've talked about, the average person, what they learn in civics class, if they had a civics class, that it takes unanimity to convict somebody. That we'd rather what I remember growing up was we'd rather let 90 guilty people go free than to send one innocent man to prison. I don't know that we still think that way. But the point is, these people started to get a lot of public support. They started talking to legislators, and eventually the legislature in Louisiana changed that statute and said, no, we want unanimity. And that's an example of, and as he talks, we could simply have intelligent people talk to Frankfurt and say, you got too many laws, here's a list of 100 you ought to do away with. Or your penalties for this are too much.
But I'm actually, the structural impairment or the structural deficiency you see is the laws that have been enacted. If you're a robber, if you come stick a gun in my face with a loaded weapon, it's 10 to 20. If you've done that or several felonies before, it jumps up to 20 to life. If you go to trial, we're like, fine, you know, this is your the jury can nullify, we all know that. If jury, like we talked about when the labor laws they didn't like, if jurors, for whatever reason, don't like a case, they refuse to follow the law and they find them not guilty, they can not and find the PFO, nullify on that, they can go with the minimums. I'm trying to, how do I give effect? If I buy into your problem, there's too many plea bargains, and I agree. And I don't think it's a Nixonian world. I got 1,000 reasons why that
Sure,
happens.
yeah, no, I think there are 1,000.
But how do I fit in that and give it effect? It sounds like a beef with the legislatures for enhancing too many things. And
I
passing too
probably,
many.
and I keep interrupting, I probably had
Still a judge.
I'll
six
sell
cases,
you a book.
six cases a year where we're gonna go to trial next week, and the grand jury indicts PFO the week before. And my sense is, it was always, prosecutor, let everybody know, if we're gonna go to trial, I'm gonna add this, just like what happened to Paul Hayes. Now, my point is, you have discretion. I assume there were cases where that could have been done, the prosecutor didn't bother. And so that would be an example where
But that's hiding from them, just like the plea bargain. It's hiding
Yeah,
for your sunshine policy, right?
Can I just say that, like, I'm not focused on the book and the gap between 10 and 20 years, right, that you might give to somebody who stuck a gun in somebody's face. So let's look at Oklahoma. We're talking a lot about Oklahoma. My wife is from Oklahoma. I love Oklahoma, wonderful state. Right now in Oklahoma, you can be fined $1 million for trespassing, right?
$1 million.
$1 million for trespassing.
you gotta keep those greenies off the pipeline.
That's right, yeah. This is an environmental sort of.
I get you.
Yeah. But this is something, an ALEC monstrosity that has sailed through, 7 or 8 different legislatures or more. And it's exemplary, the kind of thing that Judge Cunningham is talking about. The criminal prohibitions that sail through state legislatures and the federal legislature, Congress, every single year without anybody really paying any attention to it. So when Indiana's version passed, I called up my buddy who's a state senator up in Indiana, and I'm like, why did you vote for this thing? Because there wasn't a single vote against it. He's like, nobody's paying any attention to that. I wasn't on the committee, and it looked pretty good to me as a criminal bill that says, trespassing against critical infrastructure. And it allows for a $100,000 fine against somebody who sets up a Facebook group to, go and protest on a pipeline.
Right, it's a legislative.
And don't think for a minute that 100 representatives or 38 senators are sitting around debating this. That's not how it works.
My point is that that's a symptom of the total removal of the public from the criminal justice system. No one is paying attention because nobody's ever sitting in a jury box.
But the only way to reintroduce them is lay out. I'm asking for my cognitive. How do I help with your problem? I swear an oath. I'm not going to be like I refuse to enforce things. I swear an oath to enforce the laws, whether I like them or not. I lay them out there, and it seems like bringing the public back in is letting a jury decide if the $88 check guy needed life or not. Going in the smoky back room and giving him 3 is what you're arguing against. But then when I'm just saying, as a prosecutor, it seems to me like you have a beef with the legislature's gotten too heavy-handed with sentences and enhancements.
Yeah.
But as a prosecutor, I don't know how I can.
Well,
It's not my job to get in the way of that.
and you have to remember, I used to tell people all the time, just because we live in Jefferson County doesn't mean we do things in Jefferson County way. We do things in Boyle County way, because a lot more Boyle counties in Kentucky than Jefferson County. Out in the state, what a prosecutor do is not go after their elected senator representative because they have the audacity to roll back some criminal stuff, instead of saying, I'm tough on crime. So anybody notice in the Republican primary commercials, any of them saying, we need to be a little more New Testament-like in our attitude towards criminals? I missed it. It all sounded to me, they were very Old Testament. I'm gonna be hard on crime. I back the blue, baby. So that's just a little thing, but you can have a little impact on the police and potentially elected people. Scott?
Yeah, you've parroted some of his stuff in his book about too many laws and all that. Can you name 1, 2, 3 in your time on the bench, offenses that you either took a plea on or you submitted on a, you know,
Yeah.
a trial
I'll
that
give you-
were bad
I'll give you
offenses?
a perfect example. This was early in my career when meth was still being cooked locally in 2-liter bottles. I had a woman, third offense, I forgot, trafficking or meth, I think it was trafficking meth, but she had screwed up twice before. And Lisa Cartier Giroux, I'll tell you about how long ago it was prosecuted, and the plea was pleading guilty and taking 17 years. And Charlie Cunningham said, naive young judge that he was, and with all due respect, I don't need to put you away for 17 years to make this point. I'm going to send you to 14. And Lisa, in a very tactful way, said, Charlie, you can't do that. 17 is the minimum for what she has pled, the minimum. She's got to go away for 17 years. And I just said, that's insane. And she said, it is what it is. So the mindset.
My question is, okay, is the answer that trafficking in the meth is an offense? You don't want to see the legislature pass and make it illegal? I'm asking you, give me 1, 2, 3 offenses. Is it rape? Is it stalking? Is it robbery? Is it murder? Is it reckless homicide? Give me 1, 2, 3 that shouldn't have been on the books in your experience, because all you've done is parrot his thing about too many laws and all that thing, and we all break the law, which frankly I found to be one of the most ridiculous aspects of an incredibly ridiculous book. But
It's
yeah,
easier for me to
tell me 3 offenses. 2. Give me 2.
Can I give you misdemeanors?
Misdemeanors.
But
Come on, Charlie.
I'm more about the punishment and the consequences.
Yeah, well, the point is, you said there's too many laws. There's too many criminal
How
laws.
about this?
Are you against the strangulation statute that they passed a few years ago because they wanted to have something that wasn't fitting through the cracks of wanton endangerment when someone would actually strangle someone till they either peed or defecated themselves to maybe punish that? Is it laughable, sir?
No, but
You've got points you want to make. You don't want to listen to
But
me.
they fought over whether that should be a C
Yeah.
or a D. And it didn't make it through the first time because some people were adamant they wanted to be a C. And other people saying it should be a D. They eventually let it through as a C. Call me crazy, but I think you could have started off with it as a D.
Well, what would the point have been? Because you had wanton endangerment. So the point was the legislature wanted to punish a little bit more of that strangulation. Now, on the point about...
You tell me, why is it that we have more women incarcerated in Kentucky than anywhere else on the planet?
What offenses are they being found guilty of?
I don't know.
Well, you should know if you want to criticize it.
I'm just saying, statistically speaking, in a quantitative sense, we have put away more women in Kentucky, I'm told, than pretty much anywhere on the planet. And I don't believe, maybe you do, I don't believe that women in Kentucky are more criminally inclined than other places. I just don't.
Part of the real problem with the book is when you go into the footnotes and you examine them, like the case out in Utah, although you cleverly said the media fell for the prosecutor's thing, because when you examine that guy in Utah where you made a phone call to his lawyer and you relied on the defense lawyer for all the information, you know what I'm talking about? In your book.
Okay.
Your book, the Utah case.
Sure.
Sure? You know.
What happens in the Utah? I talked about 20 different states.
You don't remember? Yeah, you footnoted it, and then when you go into the footnote and you Google all this stuff, you were incredibly misleading in your book, as you are misleading in many places. One of the most ridiculous statements you made is the American Constitution. Well, first of all, you go back into history with all this class stuff, which no serious historians agree with your class warfare take on history.
I mean, I quote serious historians in the book.
Yeah, well, not really. But when you you don't even talk about the American Revolution. You spend a sentence on that. And then when you say,
about the American Revolution.
when you say the American Constitution says very little about criminal law, he's already pointed out in the Bill of Rights, bills of attainder, ex post facto laws, habeas corpus, it's full of, and here's what's scary. When I bought it, spent $30, that's okay. That's money lost. I gained, wisdom. But I saw a Post-it note from somebody that said, this book changed my life, blah, 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 blah. The problem is you're unresearched, I mean statistically off in La La Land, okay? I mean, you don't even talk about the frontier and what was going on in the frontier in the 1830s as far as justice. You don't even mention that. You go to Massachusetts and you say because these things...
You've got it all figured out. You've gone and done all the research. Like, I've presented this at umpteen universities, gone through many different editors, many different professors have vetted all this work, but you've got it figured out. But let me turn the question back on you.
Right,
Do you
sure.
think there's anything wrong with the criminal legal system in the United States today? And if so, what is it? You think, from all I'm hearing from you is everything is fine.
I didn't
Right.
say everything was fine, but I
Okay.
said your book is, it's not, it's kind of slightly dangerous propaganda because the naive and the uninitiated that don't have the sense to like look at the footnotes, which go nowhere. You quote that Wisconsin case. When you print out the Wisconsin case, you totally miss the meaning on that 1800s Wisconsin case that you put.
Okay.
That for a law professor to do that is inexcusable. Inexcusable.
Okay.
You cite the Utah case, and you do cleverly mention that the media got it all wrong because, and then you realize that the man in his deposition confessed to other crimes that he literally was guilty as sin, but you just talked to his lawyer about it. Do you even recall what I'm talking about?
Bobby Johnson's case? Bobby Johnson, who was innocent, who took a plea? Is that what it is? Is it Bobby Johnson's case?
Is it Utah?
I don't remember.
I remember Utah. I don't
Okay, you remember Utah, but not the name of the guy. All right.
Right.
I mean,
I didn't write the book.
You've done, I'm sure, but you've done all the research into it. You've done all the research.
No, I followed your line, the bird killing thing, the thing where you said the person that recaptured that, you know, and ran into Walmart, an agent and all that. You go and you read the real thing. Once they figured that out, they didn't fine her. You didn't say that in your book. She wasn't fined. You said she was fined.
Okay.
Good research is what I'm saying. What is this? The scary thing is that people will read it and they'll just take the high notes, the hyperbole.
The research has been thoroughly vetted. This is the first time I've ever heard any criticism from law professors, from prosecutors, from all the people that I presented this book to and who vetted the book before it ever came out. But you've got it all figured out. So that's, I mean, like, you've got an axe to grind, man. I got nothing against you.
I don't have an axe to grind. I
Sure
read
you
your
do.
book. I read it with an open mind.
Yeah.
Why don't you explain the innocent? You only, for the innocent guy that from Utah, you only talk to his defense attorney.
Time out, time. I want to get, is there anyone else who would like to ask a question? Yes.
Could you please comment as to whether, in your view, there is a different value for plea bargaining for first-time offenders versus repeat offenders?
I think that, I'd like to get Judge Cunningham's take. I think that certainly that is something that prosecutors are allowed to take into account, right? And it factors into, it's one of numerous factors that they can take into account when they're deciding ultimately what sort of offer they're going to put on the table. So, I think the answer is obviously yes.
Let me put it in a context that impacts me. I guess you could call this the judicial equivalent plea bargain. So I put somebody on probation for possession of narcotics, trafficking narcotics, and I get a report of probation, dirty urine, or actually found this stuff on them, or something like that. Now I have to decide what to do. Do I factor in the fact that if they have this history? Yes, I do. It doesn't mean they're going to get revoked, but it sure makes it statistically more likely. And so that's what I can speak to as a judge. I presume comparable stuff goes through the minds of prosecutors when they have to look at somebody. And we have one last question there in the back.
Just briefly, I practiced criminal law as a Commonwealth's attorney in Virginia for 30 years, and we had sentencing guidelines, and those sentencing guidelines almost ensured that a plea arrangement would be the results. A lot of states have sentencing guidelines, and I wonder if you've considered how that actually contributes to the proliferation of pleading.
Yeah, there's a bit in the book about that, and I think I'm mostly focused on the federal sentencing guidelines and what has sort of results of those things. And in particular, I talked to a former federal prosecutor who has really been one of the only folks that has been candid enough to come forward and say, I mean, someone who's very, very conservative, very sort of dyed-in-the-wool, justice-oriented guy, who is has been very forthcoming about what the sort of goals of his office were when he was the AUSA, and what the incentives were to just get the highest possible sentence to lock up as many people as possible. There is a bit in that in the book about the federal sentencing guidelines, although I don't go into it too much state by state.
But you don't think that it's contributed to the high number of plea agreements?
No, I think it. I absolutely do.
Okay, thanks.
I don't know that there's anything like equivalent in Kentucky that would push people towards a plea. Whereas you all, if you're like the feds, there's actually literally a black and white penalty if we go forward.
I think most states are not like the feds. The feds have to give a specific sentence, and in states, at least in Virginia, it was a range so that it narrowed the range that the legislature actually had determined. So it was based on historical sentences so that it was easier for the parties to agree.
That might actually go the other way in the sense that by taking some of the discretion, there's less bargaining to do. In other words, if you're guilty of X and the penalty range is 8 years to 9 years,
obviously it takes into consideration mandatory minimums, obviously, yeah.
I think the really problematic piece for me in the federal sentencing guidelines is, if you refuse to take a plea, then that can be seen as, the
You can use it as an
If you
enhancement.
insist on going to trial, then but you didn't cooperate with the prosecution, and so they can hit you harder.
Thank you.
So, and I'll say this as somebody who'd love to try, like I love trial, I would love to trial my cases. But I think the effect would end up being, our bosses wouldn't give us the discretion about not indicting persistent felonies under statute of being elected officials. And when you have a defense attorney saying, come on, and he's a kid, it's his first robbery, you got this guy on video robbing a clerk, who the prosecutor now might, because it's his first offense or whatever mitigating issue going on, might come down to a rob second. The jury can't give him a rob second, that's a gun in the video. I think you would end up with vastly harsher sentences than we get under plea bargains.
Or not.
I mean, or not guilty, but.
Yeah, no, I think that's right. I mean, I think that's right. And to answer your question from before, Mark, I think that what you can do, especially as deputy prosecutors, is limited. I mean, I get this question from public defenders all the time, like, what can we do about this? I don't think there's a whole lot. This is the system that exists. And part of my point in the book is to lay it out, like, how did we get there? How did we get to where we are now? What are the sort of the underlying problems and philosophies that got us there, and what are some potential ways that we can tweak it to make it better? I think that individual prosecutors, that are unelected prosecutors, are in a bad spot to make real changes to the system. I think the same is true of rank and file public defenders.
Well, thank you. I think those last rounds of questions show why the book has to be read. I mean, I urge everyone to get the book. And as far as Kentucky women, I'd recommend the song by Neil Diamond, Kentucky Woman. Thank you for coming, and hope to see you again in July.